Namaskar, hello, and welcome everybody to our channel Legal Voice India. Today we will be dealing with a legal topic that pertains and relates to every one of us in the society, and more specifically, this topic will deal with the aspects of ancestral property in a Hindu undivided joint family. Yes, I'll be dealing, rather, we will be dealing today of the general provisions provided under the Hindu Succession Act 1956 and Hindu Succession Amendment Act 2005. Inheritance to a property of father by a son is like succeeding or acquiring the property of the father who died intestate. Hindu Succession Act is based on the principles of Mitakshara school. Now, what is Mitakshara school? Mitakshara is one of the two schools of Hindu culture. The other one is Dayabhaga, which describes the rules and provisions for succession of a joint Hindu property in a joint Hindu undivided joint Hindu family. Now, as per Mitakshara principles and rules, the Hindu Succession Act was enacted, and it also provides for the class of heirs who can succeed to the ancestral property, whether character of the ancestral property changes after devolving upon the heirs, whether a girl child has a right in the ancestral property as a boy or a son has. All these questions and all these aspects are are covered in Hindu Succession Amendment Act 2005. So we'll go one by one to all these aspects. Now, what is ancestral property? Ancestral property is nothing but a self-acquired property by the ancestor which gained its nature as ancestral property after four generations, which remained undivided. Then such property can be identified as an ancestral property. Once an ancestral property is devolved upon the heirs or the co-partners, and the same is partitioned, the ancestral property ceases to the character of the ancestral property ceases to be a co-partnery property. But there are several judgments of Supreme Court on this aspect. Even contradictory judgments are there, one of which is Vallimai Achi versus Nagappa Chettiar, that is AIR 1967 SC 1153. In this judgment, it was held that even after the ancestral property is partitioned, it doesn't changes its character, and it still remains as an ancestral property so far as sons are concerned, that is male issues are concerned. He unless a son is born out of his marriage, the moment son is born to him, that son on his birth has obtained a right into that property being ancestral property. So unless and until the son which is born to the here who obtained property from an untested father, then that son has to either relinquish his right in the property or may ask for partition in the property, and the father and the son will then get equal share in the property, and then the share of the father he can uh, further sell it out. So what I mean to say is, if there is no male child to this fellow who has obtained the ancestral property from his father, then of course he can sell it further uh, after the preemptory rights are denied by other co-partners. But if a male child is born to him, then that property still retains the character of co-partnery property. Further, uh, in the 2005 Amendment Act, a very crucial provision was introduced in the Hindu Succession Act, that is under Section 6, which provides equal rights to the female or a daughter, let's say, into the co-partnery property, joined in the family property, as if she is a son. All the rights which are there for a son, the rights and liabilities pertaining to the co-partnery ancestral property, are now also given to the daughter. She is equally entitled to the ancestral property along with the sons. Now, a daughter becomes a co-partner in the joint Hindu family property, and there was a confusion whether this act will apply retrospectively or prospectively to the daughters, whether uh, the daughters born after the commencement of the act or before the commencement of the act, whether the joint Hindu family property was in existence and the father of this daughter was surviving, was alive or not before the commencement of the act. All these issues came forward, came for the discussion, and there was a confusion whether this daughter who has got right into the ancestral property now by virtue of this amendment, whether this will apply to all the daughters or only the daughters who are born after 2005, that is 9 September 2005, the date of commencement of the act. Then this was a gray area. So Supreme Court came forward and delivered a landmark judgment, that is in the case of Vinita Sharma versus Rakesh Sharma. In the year 2020 it was passed, wherein it was made clear that Supreme Court held that a woman or a daughter shall also be considered as a joint legal heir as a son and can inherit ancestral property equally as a ir- uh, male heir would do, irrespective of that the father was not alive before Hindu Succession Amendment Act came into force. Alive, whether or not the father was alive or dead, that doesn't matter. Irrespective of that, the daughter will still have right in the property, ancestral property. So this was made clear in Vinita Sharma versus Rakesh Sharma. Now, further let us see who are the heirs under Hindu Succession Act. That is provided under Section 8 of the Act. There are two classes of the heirs provided in this Act. That is Class 1 and Class 2 heirs. If in case there is no survivor of these two classes, neither one nor two, then the property will go and devolve to a class 3 here, that is agnates and cognates of the deceased. Now let us see who are the class 1 heirs. Class 1 heirs include sons, daughters, widow, that is wife of the deceased, and mother. These are the class 1 heirs. Class 1 heirs also include, if the son or daughter is no more, then class 1 heirs also include son of a predeceased son or daughter of a predeceased son. Similarly, son of a predeceased daughter or daughter of a predeceased daughter. Now, if none of these is alive on the day when the person dies intestate, then the property will devolve upon class 2 as provided under section 8 of the act. Class 2 heirs. Now, who all are there in class 2 heirs category? Class 2 heirs are father first. Secondly, if father is not alive, then the second list will come, that under class 2 here, that is sons, daughters, son, sons, daughter, son, sons, daughter, daughter, or brother or sister of the deceased. Now, third list, daughter's son's son, daughter's son's daughter. Similarly, daughter's daughter's son or daughter's daughter's daughter. A fourth list, brother's son, deceased, and we are talking about these all relatives are of the deceased, so don't forget. But for a better understanding, whatever list I mentioned till now, whatever relatives I mentioned, these are all of the deceased. So look it from that point of view, so it is very easy to understand. So now the fourth list, brother's son, sister's son, brother's daughter, sister's daughter. So brother's deceased brother's son, deceased sister's son, or deceased brother's daughter, or deceased brother's sister's daughter. So this was the fourth list. Now fifth list. So father's father or father's mother. So that is when we look it from the deceased point of view. So father's father is grandfather of the deceased, and father's mother is grandmother of the deceased. Now sixth list, father's widow and brother's widow. Now many of you would uh, I mean would come up with a question, why there is a word father's widow. Brother's widow we can understand. Father's widow is nothing but if in case a father had more than one wife, legitimate or illegitimate, but that denotes father's widow. This word denotes to that particular person who was other than the original mother, the widow, because this mother is there already there in the class 1 years, class 1 years. So this father's widow could not be the same. So mother is already there in the class 1 here. So this father's widow denotes to a person which is other than the original mother. So now seventh list, father's brother or father's sister. So it's like uncle and auntie. Eighth list, mother's father. Now we are coming to mother's side, uterus relationships. So now we saw father's relatives. Now we are coming to mother's relatives. So it's mother's father, mother's mother. Ninth list, mother's brother and mother's sister. So these were the class 1 and 2 hairs. Now none of the relatives are surviving out of these two classes of hairs. Then the property will go to the agnates first, and if there are no agnates, then it will go to the cognates. uh, just to understand what is agnate and cognate, agnates are the relatives who are born out of genealogy, or born out of male child, relatives um, arising from the male side of the child, I mean children. And cognates are towards daughter's side. There is another important aspect and another question which often comes into the mind, or a curiosity which comes up, is whether a child born out of a subsequent marriage, whether legitimate or not, can inherit the ancestral property. So the answer to this is yes. The child born out of a subsequent marriage, as there is no polygamy in Hinduism, only one marriage is allowed. So this is why I'm saying subsequent marriage. And once a person does more than one marriage, the subsequent marriages are considered to be illegal or illegitimate. So a child born out of this illegitimate marriage will inherit and will have a right of inheritance in the ancestral property. That was confirmed in various judgments of Supreme Court, one of which is of Revana Siddhappa versus Mallikarjun, which was passed in the year 2011. Now, the principle which was laid down was child born out of a void or voidable marriage has a right to inherit the ancestral property of his parents, his or her parents, whether ancestral or not, or self-acquired, he'll still inherit the property. Now, this was held in consonance with the provision as provided under Hindu Marriage Amendment Act, under Section 16 of that. Now, we went through various provisions. We discussed the basics of the Act. It is based on Mitakshara School of Law. We discussed how, after the Amendment Act, a daughter has also got equal rights in the ancestral property, rights and liabilities. We discussed what are the heirs in class 1 category, class 2 heirs category, agnates, cognates. We discussed how will be the property, in what proportion the property will be devolved between the co-partners, between the legal heirs. We also discussed uh, about the rights of a child born out of a void marriage, avoidable, illegitimate marriage. So that's it for the day. If you have liked the video, please subscribe the channel Legal Voice India. Share, and we'll meet again in our next video. Be connected to Legal Voice India. We together can make change in the society. Thank you.